Welcome, everyone. Um, we're going to wait a few minutes for everyone to get in and then we will start. But we're so glad that you're here. Welcome again, everyone, to our St. Edward's webinar around basic estate planning. I'm Gregory Perrin. I serve as the Associate Vice President for Development here at St. Edward's, and we're very happy that you have joined us to just learn some of the basics around estate planning. We know that this is a very important piece of your legacy, and hopefully the items and information that we present today will be useful for you as you plan for your future and your family's future, and perhaps any of your charitable ambitions for the future. I do want to say that this will be a high-level overview. It's very interactive, so please use our Q&A function for any questions that you have. Our presenter, Vince, will be reviewing some tax planning ideas, but we won't be able to cover and be very in-depth on everything. So if you have a specific question, please enter in the Q&A. We'll address it if we can during the webinar, and if not, I'll be happy to follow up with you. As we begin, we have a few poll questions just to get a sense of everyone's estate planning process and where they are in their estate planning. Our first poll question, which will be coming up shortly, is: have you updated your will, trust, or estate plan in the last 5 years? So I'll give you a moment to respond. Okay, as responses are coming in, it seems like the majority of us have not updated it. A few people have, which is wonderful. Um, but it's important as life goes on that we do revisit those uh, pretty much about every 5 years, especially with any new additions in your life, dealing with marriages or family as it grows. So that's a very important piece of this, and we'll talk more about those items during this webinar. Our second question, which will be coming up shortly, is: which of the following assets are taxable to heirs regardless of your estate size? So be thinking about these assets here. Which of the following assets are taxable to heirs regardless of your estate size? Is it real estate, marketable securities, your 401ks, 403bs, Roth IRAs, life insurance, or none of the above? Of these assets, which of them are taxable to your heirs if you leave these assets in your estate to your heirs? Okay, I'll give you a few minutes to respond. Okay, there's some thinking going on. All right. So it looks like many of us are thinking that our 401ks and 403bs are taxable to our heirs. Real estate is taxable. Marketable securities are taxable. And so some of these responses are correct, but to get the real answers to this, I will introduce Vince McElligott, our facilitator for today. And remember your responses here because he's going to address these directly. Um, Vince has been doing estate planning and advising for more than 30 years. He works with universities, large nonprofits, hospital systems, and is a national expert in this area. And we're fortunate to have him today with us. So, Vince, we're ready for you.
Well, thank you, Gregory. It's a pleasure to be with everyone today. As Gregory mentioned, I'm going to share a little bit of information about some general estate planning questions and kind of talk about the big picture, but also want to, as Gregory mentioned, give you all an opportunity to get your questions answered today and at least hopefully give you some feedback in preparing and planning your own situation. When we think about estate planning, I like to really begin with this question. And just like Gregory did, I want you to take a moment to reflect and reflect from this standpoint. If you were given a large sum of money today, what would you do with it? And I'm going to put two stipulations on that. One is you cannot spend it on yourself. You can't hide it under your mattress. You can't invest it. And you have to do something with it right now. So just give you a couple seconds to think about that. That it's got to come into your hands and then it's got to go out. Now, I want to ask you another question. Is that what your estate plan does? And this is why it's so important to think about it because there is this one time in life when everything we have is going to go somewhere else. And so that large sum of money in your mind could have been $50,000 or $1 million, whatever it was in your mind. Does that does that reflect what your estate plan is? And if it doesn't, I think it's really important to come to this conversation and begin thinking about, does your plan reflect your values? What's most important to you? Now, I want to highlight a couple of, let's just call them mistakes that have been made. And we think often, well, everybody else probably has their things figured out, but we might not. But in reality, that's not the case. And we think sometimes celebrities, for example, or wealthy people have got, the greatest advisors and they have it figured out. But here's six individuals who didn't. Aretha Franklin passed without a will. Michael Crichton was married 5 times and didn't include his fifth wife in his estate plans when he passed. James Gandolfini didn't take advantage of the unlimited marital deduction, so therefore his estate ended up paying a significant amount in estate taxes. Uh, and we can go on and on in regard to that. Michael Jackson, for example, didn't had a revocable living trust, but didn't fund the trust. Jackie O had significant charitable intentions, but they were never executed by her children after her passing. Etta James, a famous singer, lacked capacity to complete and execute a power of attorney. And so we often think that people have these things figured out, but often without really thoughtful process, they may not. But there are many other common mistakes in estate planning. For example, not planning for income taxation of IRAs or retirement plans at death. And for those of you that got that question right in regard to what's taxable, typically that's the big asset that's in our estate that has an income tax liability, regardless of how large your estate is. In the second box, it's really failing to use both spouses' exemptions from estate taxes. Beneficiary designations, these forms not being updated to reflect our chosen beneficiaries. How many of you created or filled out the beneficiary designations, maybe when you started a job or you opened an IRA. And perhaps that might be the last time you looked at those. Well, it may be time to revise or update those based on your wishes. And because things change over time, we might want to make sure that from time to time we look at those beneficiary designations. Uh, Inheritance not tailored to your heirs' needs, capacity, or abilities. Inheritance not protected from divorce, litigation, or liability. We often look at children or heirs that we may leave something from, and if they inherit, they commingle with a spouse and potentially go through a divorce or have some other legal issues. Some of that family inheritance may leave the family. Or planning maybe doesn't reflect your personal values and objectives. So there are many ways that our estate plan can go awry without really thinking about our own personal goals and values and what we would like to accomplish. I think estate plans should be very thoughtful, reflective of our true intentions and values to make sure that we have desired outcome for our family or other heirs. We should take into account some of the tax ramifications that are potential in our estate. Updating those from time to time based on life or circumstances or changing goals. Estate plans aren't a set it and forget it type of an ordeal. Because life moves on, sometimes we want to update our plans based on those changing circumstances. In reality, plans are often avoided. I don't know if you know it, but about 60% of Americans die without even a simple will. They're often done in a hurry when they are done. It may be, I'm going, to Europe, and what if the plane goes down? Well, I want to make sure that things are taken care of. And sometimes because of that, there's not a lot of thought that's put into it. Or we may even go to the attorney and say, I need a will. And the attorney will say, what would you like to do? Well, I'm here for a will. And so it's important that we take advantage of the opportunity to really have a thoughtful conversation with that advisor to make sure we're using their high quality counsel. Or perhaps we don't provide for our heirs in the most suitable way. So thinking about creating a plan really requires us to maybe stop and think about some of the common planning goals. A lot of times people begin here with what I would say box number 4. Who gets our stuff when we're gone? And yet, I think estate planning is the entire continuum here. This is really about accumulating and building an estate, perhaps when we're younger, prior to retirement, improving our standard of living and maintaining that through our retirement years. But part of estate planning should also be about identifying the possibility of diminished capacity, making sure that we are provided for in case of disability. So I'm really talking about the power of attorney and life and living. And so our estate planning should encompass this entire continuum. But I think it should also address 3 primary questions. It is more difficult to create a plan if we aren't sure if we have enough money for ourselves in our own lifetime. So financial independence should be really the base or the foundation of that plan. And then what is our family legacy? How much should we leave our heirs? And so if we're a single person without children, for example, we can think of our heirs in any way we choose. If we don't create a plan for ourselves, well, the state of Texas or wherever you may live would craft the plan based on that state's intestacy laws, which might follow the bloodlines. If we're married and if we have children, it could be a different formula. But when we craft our own plan, we can include any individual or organization that might be important to us. So if we've thought about financial independence and then family legacy, the next question is what I would call the social capital question. There may be part of our estate that we can't give to family or others, and that may be in the form of tax or potentially a gift to our favorite charities. And so would I rather have my executor or trustee write a check to the IRS or my favorite charities? And so I think this is really beginning with the foundation and then building on our plan that should reflect our personal goals and objectives. I'm a firm believer that your plan should begin with your personal values, your goals and objectives. So if you can identify and articulate your values and determine the goals and objectives, then the plans and tactics to get there should follow. Some of the common values that I often hear is, well, I'd like to benefit those people that are important to me, could be family or others. Vince, if there's a way to minimize or eliminate taxes in my estate plan, that would be a benefit. And then I want to support maybe organizations and things that are important to me. So these are often some of the ones that, and as a planner, that I help people think about to accomplish their individual goals and objectives. There are many different things that may influence your personal plan. One, one area are those factors that are unique to you. For example, changes in net worth. Over time, our wealth can build just by saving, investing, owning real estate or stocks or bonds, maybe inheriting property from other individuals or the sale of a business. Our family might also change. If you're a young person and married and have children, well, one day those children may grow up and leave the home and get off the payroll and have families of their own. But there's marriages, divorces, and grandchildren, and all these other factors that might influence and give us different milestones or opportunities to update our plan to make sure we've addressed those areas that have changed. And sometimes those individuals in our lives have changed. I talked a little bit earlier about the power of attorney. Well, the power of attorney in many ways is really about life and living. And so if we are disabled, who are those trusted individuals that we would want to serve to maybe as the healthcare power of attorney to talk to the doctors and others to make sure that our care is what we would want. And some individual that we've identified, it's important to have some backups as well in case that person cannot serve and have a primary and then have a contingent in case that person can't serve. And so for the power of attorney, guardianship for children, the executor or the trustee or personal representative of our estate. And then the goals and objectives from time to time can change. So when we think about our own goals and objectives, it's really about all of these factors that might influence our plan. Another reason why a plan that you created 15 to 20 years ago may be outdated. There's also external factors that could influence our estate plan. Just in the last 9 years, there have been four significant changes to tax law, starting back in 2017 with the Tax Cuts and Jobs Act, and then the Secure Act of 2019 and the updated Secure Act 2.0 in 2022, and then this last year, last summer, the one big beautiful bill that extended those tax rates and increased the federal estate exemption amount that was signed last July. So sometimes these will influence our plan, sometimes they may not. But the 2017 Tax Cuts and Jobs Act was due to expire in December of last year, and the one big beautiful bill extended those laws permanently. Now, I want to mention something about permanence in Washington, D.C. Those laws are on the books as permanent. However, any future Congress or president can sign new laws into place. And so those things may change over time. So it's important to keep a pulse on those things as things move on. Now, one of the things that I like to highlight in my discussions with individuals is really when we think about our estate, what does that mean? People might tell me, Vince, I don't really have an estate. I've got a home and I've got an IRA. but in reality, it's anything that you own. And I think it's really about two sides to your estate. The first being those assets that would be governed by a will or a revocable living trust if they're titled to your revocable living trust. So I'm going to call that the probate column. So if you have a will, all of these assets on the left-hand side of the screen, like your home, your business interests, other real estate, whether it's commercial or a vacation home or a farm, bank accounts, investment accounts, and things like that that are taxable in personal property will pass through probate. Okay. If you have a revocable living trust and they're titled to the trust, then the trust would govern those assets. So that's one way where we can avoid probate. And probate can take time and it can take and it does cost some money. Texas, it's not a terrible process and not that complicated, but there is time and money that's allocated to probate. So those assets on the left-hand side of the screen typically are assets that would also pass to family members with no tax liability. For example, if I bought a rental property and it has appreciated significantly in value, and I might have even depreciated that significantly over the years, and if I were to sell it during my lifetime, well, I may end up paying capital gains taxes. If my children or other heirs inherit that property, they get what's called a step up in basis or date of death market value. And so their basis in that property is the date of death market value, and no taxes would be due. As long as your estate is below the federal estate exemption amount, which today is $15 million per person, and Texas does not have an estate tax, and so many people won't have an estate tax issue. Now, on the other side of the screen, we have what I would call contract assets. So it doesn't matter what your will or trust says, it matters what your beneficiary designation is. What does the form say that you drafted with Fidelity or Charles Schwab or Merrill Lynch on your IRAs, your 401ks, your 403bs, 457s? Any of these retirement plans, including the Roth and life insurance. Now, we want to list the beneficiaries on there, but it's also important to have some contingent beneficiaries on there. For example, if you're married and you have these listed for your spouse and then children, you want to have the children on the contingent beneficiary line. So if your spouse predeceases you and you've never updated that form, then it would go to the children. One thing I would want to really stress here, this is typically where the taxes are hidden in estate plans. There are probably fewer than 99.9% of estates that will be settled in 2026 that will have an estate tax issue. But 85% of those individuals will have assets in this group, and those are all subject to income taxes. Now, if we leave these retirement plans to our spouse, they have the ability to stretch those out over their lifetime, but no one else does. So our son or daughter or our best friend can inherit those from us and they can cash them out immediately, pay taxes on it, or potentially roll those into an inherited IRA and stretch those out for a maximum of 10 years. So in many cases, our heirs, other than spouses, will end up paying more taxes on those assets than potentially we would have. Our plan might be, well, let's leave it all to our family. That's seldom possible, as I mentioned earlier in the last slide, and it's really because of that tax burden. But if we're charitable, there may be an opportunity to reduce that tax bill and also provide some gifts to our favorite charities. Let me give you an overview of the will. So what are the key components of our last will and testament? Our last will and testament will have an exordium clause. It just says, "This is my last will and testament." It will identify all of the people, starting with the person who passed, who is called the decedent, and then identify, family, maybe spouse or children or grandchildren or other heirs in our plan. We can also make specific bequests, like I want my rental house to go to my son, or I want to make a gift of my retirement plan to someone. A residual bequest could be after all specific bequests have been made. Whatever's left over might be divided equally amongst my heirs or gifted to an individual or charity. We can also make a contingent bequest. I might want to leave something to my brother, but if he predeceases me, it goes into the residual. We also select the executor. Who is that individual who will present our will to the probate court and begin the probate process? Once they do that and it's approved, they become the administrator of our estate after we're gone. We often hear questions about revocable living trusts. And if we have a revocable living trust, we can skip probate. Revocable means it's 100% changeable. So during our lifetime, it's changeable unless we become disabled. And disabled in the sense we have diminished capacity, and then a successor trustee would step in. So it doesn't provide us any creditor protection. It is our trust during our lifetimes, and it uses our social security numbers. So if we make income, everything passes through to our 1040 tax return. And so during our lifetime, we are both the grantor or the creator of that trust. We also serve as the trustee, and then we're the beneficiary. So it doesn't keep us from buying or selling, or if we want to downsize our house and go to a smaller one, we can. Uh, and then at our death or disability, it becomes an irrevocable trust. So our plan is in there. Our core of our estate plan is part of that trust. And so at our death, the successor trustee will step in, get a new tax identification number from the IRS, and now it is an irrevocable trust. So our plan is our roadmap that will be followed by that individual to either distribute our estate or provide for ourselves if we're disabled until our death, and then distribute our estate how we choose to our named beneficiaries. So when you think about estate planning, it's really about building your plan, building your house. So it begins at the foundation with the financial power of attorney and the power of attorney for healthcare, and what I would also call the living will. The living will is not really a will at all. It is a directive to physicians. Sometimes we hear, the DNR or these other things. It's really about end of life decisions. What would we want for ourselves in case we maybe have a terminal illness? And so, and so building on that, we would have the last will and testament. Perhaps we would also have a revocable living trust. If we have that revocable living trust and all our assets are in the trust, we would still also have a will. But the will would be a simple will that basically says at the end of my life, if there's something I forgot to put in the trust, pour it into the trust. So that pour over will is POUR. So its simple will is just taking whatever's left over and putting it in the trust if we forgot to put it there. And then there might be some basic asset planning, basic charitable planning, and then there's many more different layers potentially to have more advanced planning, both for family and taxes, to preserve and protect those assets for our heirs or even make some charitable gifts. Often, estate planning is what I would call an outright distribution. So at the end of my life, everything goes to my heirs. Well, we're seeing some differences in trends, and many of the people that I work with, they feel, they want to provide for their heirs in a smart way. And it may not be to get all of the wealth to their heirs as quickly as possible. And for a lot of different reasons, every family is unique. Some heirs may not be well equipped to manage an inheritance. So it may be better to provide some outright, maybe an annual stream of income, and then lump sum distributions at certain milestones. Those could be age related or something else. So sometimes when we're thinking about creating annual distributions and lump sum distributions over time, it's really about creating a plan where we hold and retain some of those assets in an irrevocable trust for the benefit of your heirs. This provides the instructions and maybe professional management to hold and manage those assets in the case where youth and maturity might be an issue, or maybe we have a spendthrift child or a spendthrift heir, or potentially we want to have some charitable intent as well and provide for our family, but also provide for our favorite charities after a period of time. So where should you start? Often, I encourage people to really kind of think about your family's current needs, and families can, you can extend that to anyone who you would want to provide for, whether they're family or extended friends or others. So it should be really about concern about your heirs and maybe thinking about, their abilities and if they have any special needs. Often we're planning for children first, but we tend to live much longer these days. And so we may also want to include grandchildren. Often when I'm visiting with individuals and they tell me they want to do something for grandchildren, the question that I ask them, what is it you want to see for them? And sometimes there's an amount, but often it relies on a conversation about the expense of education, university education, whether it's St. Edward's University or some other institution, that they see that as an expensive burden or maybe a down payment on a house. And so kind of giving them a leg up in life. And then maybe friends or other people that may be important to you. So organizations you care about. If you don't have a will or trust and you're charitable, and it's interesting that about 85% of Americans give to one or more charity every year, and yet only 5 to 6% of individuals have a charitable estate plan where there's a gift coming from their estate to their favorite charities. And I think a lot of that is just a lack of education around it about how to go about it. So if there are some that are important to you, and you want to focus on a program purpose or cause that motivates you, your personal legacy can be much more than just a financial legacy to family. It can also be an extension of your life, honoring that organization that's been a big part of your life, or recognizing somebody that's important to you. The gentleman in this picture is actually my father. He passed away 6 years ago this month, right at the beginning of the pandemic. Uh, I am one of 8 children, and he left his inheritance to all of us, but he included 3 important charitable estate gifts. He was actually in hospice at the time. This was the last day. I wheeled him out of his home. He was a life, he he had a big life. He was an Air Force pilot, and he retired in 1973 from the Air Force. And he was a farmer after that, almost until he passed away. And that was a big part of who he was. And he wouldn't really talk to you about farming, but you could sit down and talk about airplanes all day long. And he just loved that portion of his life, and it was very important to him. But also, he wanted to recognize my mother, who passed away 32 years ago. We started a scholarship fund in her name. And so one of his gifts in his estate plan was for that. Another one was for his church, and another one was for his Catholic high school, and then one for his Catholic university in Portland, Oregon. And so we can create a plan that takes care of family and takes care of those things that are really important to you. Now, I want to talk a little bit about the importance of an opportunity, I think, in planning in regard to the taxable assets. For most of us, a good portion of our estate will pass without any tax, and yet these retirement plans are all funded with pre-tax dollars. So they come out to us as ordinary income, therefore they're taxed, and they're going to come out to our heirs as ordinary income the same way. Now, we can change those beneficiary documents at any time. They're very flexible. We don't have to go back to our attorney to do that. So if our plans change, we can always update those. And so any designated beneficiary is permitted. Individuals and charities are fine. And so I think these are very, very important and useful tools when we're talking about charitable giving in reducing taxes on our estate. So carefully considering the loved ones and causes that matter most to you. I love this quote because I think we can have all three of these in our estate plan. Anyone can count the number of seeds in an apple, but no one can count the number of apples in a seed. And so it is with your legacy. And so when we think about the charitable legacy, I think there's an opportunity really to make an impact long term as a reflection of what's important to us. You don't have to disinherit your family to also have a charitable plan. I think in my own family, I have a unique situation that's probably not that unique. My wife passed away 9 years ago, and I remarried 3 years ago, and so therefore I have a blended family. My wife had three boys, and her middle son passed, and I have two children, a son and a daughter, and now between us we have five grandchildren, and there's another one on the way. So many families have different structures. And so there's some real opportunities, both, with blended families to think about how do we take care of each other, take care of our family, the other things that are important to us. But if you're a single individual, sometimes you might even struggle with, who are my heirs? You know, do I leave things to my siblings? Do I leave things to my nephews in LA that I haven't talked to in 10 years? There are some real questions that are really important in reflecting on what's most important to you. But I think you can do both. So let me highlight a couple things. One, just on that retirement plan scenario. Let's say there's a family that have an estate valued at about $1 million, and they have a gift in their estate plan of $100,000 for the university, and the rest of it's going to go to their heirs. And so they have that $100,000 in their will. Well, if the $300,000 IRA goes to family members, clearly, as I mentioned earlier, the family will end up paying income taxes on it. So they're going to pay federal income taxes. And if they also live in a state that has an income tax at the state level, that would be included in their income there. And they may pay income taxes at the state level too. So they're going to get something less than that $100,000 from the IRA. So on the right-hand side of the page, it shows that family would get $810,000 because they will probably pay about $90,000 in income taxes on that $300,000 IRA, and the charities will get $100,000. However, if we use the retirement plan and make a $100,000 gift to the charity, which is tax exempt, they will not pay any taxes on that $100,000. And the other $200,000 of the IRA will go to family. And so they will still pay $60,000 on that tax, or probably about 30% of it. And so the family will be better off by about $30,000 just by making the switch where the gift to charity comes from. So it's real important to think about that. And then going back to the flexibility that I mentioned earlier, this gives the donors the opportunity to update their plan at any given time. So how does that look? So at the first death, everything goes to the surviving spouse. Remember, I mentioned the beneficiary designation of having 1/3 of the IRA go to the charity. So after the second death, the retirement plan, 1/3 of it, or $100,000, would pass to the charity. and the remaining assets would go to family. So the family will get $200,000 of that IRA, so they will still end up paying some taxes on that retirement plan. So this is using a beneficiary designation instead of a will. Let me give you one more example here. Laura, a faithful donor, a single widow. She's philanthropic, long-term giving history. She's given and included an estate gift for her favorite charity. And she would like to make a bigger gift now, but she is concerned about her income stream. She has a $200,000 IRA and a $500,000 home and a few other assets. Well, one of the ways that Laura could make that gift is create a charitable gift annuity directly from her IRA. That $50,000 or $55,000 that she could make could pass to a charity, and in return for that, she would be able to receive a lifetime stream of income based on her age, and the remainder at the end of her life would be used for the charity for whatever purpose. It gives her the ability to make a gift now and yet still retain that lifetime stream of income. Because it comes from her IRA and goes directly to the charity, it is not a taxable event. This is called a qualified charitable distribution from her IRA. And this is a one-time opportunity to make a gift of a charitable gift annuity. So how does it work? It comes from Laura's IRA, goes directly to the charity, and in return, they pay her a lifetime stream of income. Now, if she had a large IRA, and I work with many people that do, they sometimes get to the age of 73 and they say, you know what? We don't really want to take all that income because every dollar that we take out, I have to pay taxes on it. So the beauty of this type of gift, it counts as part of her required minimum distribution. So if she didn't have to take any more money out, it would not be taxed to her, and it counts as a required minimum distribution. And so therefore she can avoid taxes on that. And once you're 73, you have to take out the required minimum distribution. And at the end of life, at the end of her life, the income stream ends to her, and the remainder goes to the charitable organization. Let me give you another example. Gary, the accidental landlord. Sometimes this happens. This gentleman, retired professor, had an estate valued around $3 million, had two children. He decided to downsize from the family home and move into a smaller home. And he didn't feel that the real estate market was strong at the time, kind of like now. And he decided to rent his house instead of selling it. And he liked the stream of income that came to him from the rental, but he got tired of managing the rental and thought, well, is there another way to do this? He has 100,000, or excuse me, $1 million in retirement funds, and he's interested in leaving a gift in honor of his late wife. So one solution is that we donate the house because he's tired of managing it. And every year he's gotten older, it seems a little bit more of a burden. He donates the house to the Charitable Remainder Trust. The Charitable Remainder Trust allows a tax-free transfer, and all the capital gains on that property are avoided on the sale. Gary gets a tax deduction of $374,000 in the year he makes that gift. And he gets a lifetime stream of income, or potentially a stream of income up to 20 years if he wanted to do a term of years trust. And so he's guaranteed in the first year an annual income of 50,000. So over a 20-year period, for example, Gary would receive $1 million in income, assuming the trust grows at 5% and the trust pays out at 5%. At the end of the term, it's estimated the charity would also receive $1 million. Okay, so Gary gets the tax deduction right up front. He gets a guaranteed lifetime stream of income. and the charity also benefits. So those that are looking at ways to make gifts and create an income stream, this is a very handy tool, and you also benefit from some significant tax benefits up front. But let's say Gary says, I don't want to give up those assets. I don't know what the future holds. What if I need that money? Well, he does have that $1 million retirement plan, and he doesn't like the fact that his boys would inherit that and they'd have to cash it all out within a 10-year period. Meaning his boys, both of them were doing very well, and he felt, well, I don't want to disinherit them from this retirement plan, but is there a better way? Is there a way to stretch that out? And this is what's called a testamentary charitable remainder trust, like the previous example, except we use the retirement plan to make that gift. And it only happens after has passed away. So at the end of his life, whatever's left in that retirement plan goes into the charitable remainder trust. And then it pays out an income stream to his boys for 20 years. So it stretches that income out over a period of time, and he would benefit, or his estate, excuse me, would benefit from an estate tax deduction. And so these assets in his retirement plan, there's no tax when it's transferred, assuming, once again, that it's a 5% growth and 5% payout. His boys would receive $1 million over that 20-year period. And charity would also receive $1 million at the end of that trust period. And so this is a great way to give yourself the flexibility if you need those resources to hold those and keep those. And at the end of life, make a significant impact on your family. So the 2 million of other assets can go to the boys right away. The retirement plan can come to them over a period of 20 years as an income stream, and then also have that charitable remainder that goes to the charity to benefit and recognize him and his late wife. So I just kind of want to end here, be happy to answer any questions. I encourage you, if you do not have an estate plan, there's no time like the present to really think about your personal goals and objectives. I know Gregory has tools that can maybe help you in thinking about that. If any of the concepts or ideas that were shared today, Gregory, would be happy to connect and help illustrate some things that would be useful. Uh, I'm going to turn it back to you, Gregory, and if
Thank
there's
you.
some questions or ideas into anything that I've covered today, be happy to answer those.
We appreciate that. And you can leave that slide up, Vince. Are there any questions? Please put any questions in the Q&A. We have a few minutes to address those. If there are questions about a will versus a trust or more information on how to take care of heirs who are disabled and things of that nature, feel free to put that in the Q&A. We have a few minutes to address that, or anything that you feel is unique to your own uh, individual situation. And of course, as Vince has said, my contact information is there, my email. Please reach out to me. I'm happy to discuss any of the ideas and information that Vince mentioned today. And many times we will bring Vince in on that call. We do have a question. What is the best way to find an estate planning attorney? And I'll let Vince address that.
Excellent question. And I'm happy to hear you say estate planning attorney, because just like physicians or many other professions, individuals specialize in their area of expertise. And I think it's important to identify those individuals that are estate planning attorneys as opposed to those that might be doing real estate contracts or other types of the law. Uh, Now, I do kind of keep a list of some in the Central Texas area, but there are some tools. And so there's some the Texas Bar has a specialization for estate planning, and there's actually a website. And so I'll give that website to Gregory, and so you can actually look if you're in a particular area or town and you want to identify who has that specialization. You could look them up there. Uh, Another good way is to talk to other people you know and ask maybe, who have you worked with to do this? Do you have a recommendation? Uh, I've got a list of people I know, but I think if you look at it and you identify two or three, there's a couple important things is find out if you can get have a conversation with them that doesn't cost you anything up front. Number one. Number two, sometimes looking at the age of that individual is important, not to discriminate, but you want somebody that might be around for a little while to help in case you need to make some updates. And, there may be the most seasoned person out there, but if they're a year away from retirement, that would require you to maybe make a change. And so if you keep it with somebody that might be around for a little bit, it'd be very helpful. And then finally, I encourage you to have a conversation with two to three because part of that conversation really needs to be about your comfort with them. Okay. And so I will share that link with Gregory, and there will be a follow-up that comes out to everyone. Uh, and Gregory, if you can keep that in your email, you can search for that special designation of estates and trust specialty. I think that's really helpful.
Thank you, Vince. There is another question. Is it safe to do a will online?
Well, you won't be harmed by doing a will online, but it may not work out the way you'd planned. And let me tell you why. Uh, we can go on to WebMD, we can go on to ChatGPT and try to diagnose our health issues, but I would still go to the doctor, right? And I would still do the thing, if I was trying to create a plan to really be thoughtful about, all the things I talked about. There are uniquenesses to your family and maybe your wishes and your goals. And we can make some serious mistakes. My first couple slides showed about some of those mistakes. And until you talk to a professional, and quite frankly, I don't believe there is a substitute for a well-qualified estate planning attorney to guide and counsel you and draft your documents. And I've worked with a lot of wealthy people and just a run of the mill, folks like you and I that have some mistakes in their plan. And it's not necessarily because they didn't have good advice, it's because we didn't share with those advisors all of the uniquenesses in our wishes. And I wouldn't encourage the wills online for that reason. Yes, you can get a will and maybe it'll work, but maybe it won't. And if it doesn't, we could create a situation where it harms your family. None of us go into this estate planning conversation thinking, you know what? If none of my kids talk to each other after I was gone, wouldn't that be a great result? No. We plan our estate because of the people we care about. We plan our estate because of the people and the organizations maybe that we love and are important to us. And so we don't want to be thoughtful about that. Yes, does it cost money and is there some expense? Uh, yes, there is, but the expense and the heartache of having a plan that doesn't work for you is significantly higher than not getting good counsel.
Thank you. Thank you, Vince. Thank you for that question as well. If there aren't any other questions, we still have a few moments. I do want to thank Vince for his time and expertise in presenting today such great information. As well, I want to acknowledge Dignity Memorial, one of our university sponsors. We appreciate their support. And thank you all for attending. Again, my contact information is there. Feel free to send me an email if you have additional questions, or if you would like to discuss a gift to St. Edward's to support any of our programs or student scholarships or anything that is in your desire, I'd be happy to have a conversation with you about that. We appreciate you. Thank you so much.
Thank you.
That ends our webinar.